Okay, welcome everybody. My name is Mark Trapp. We're going to jump right in with going through withdrawal. You see a little bit about me here on this slide. Stick around, there's a picture at the end. It's something you might want to stick around for. We will jump right in because I've got a lot of information to cover here, and I want to get to as much of it as possible. I'll try to end within the hour. If we go a little bit over, I apologize, but I'll try to make it within the hour. I've included a lot more information than we may be able to get to on the slides, but I wanted everyone to have that. If I skip over or don't cover fully some slides, you can reach out to me to cover those, but I wanted you to have the information, even if it's not fully covered. So let's jump right in here. I'm going to assume some familiarity or background on the part of everyone on this call with the Multiemployer Pension Plan Amendments Act. You might not know the name of it, but that's the act that created withdrawal liability back in 1980. You probably wouldn't be on this call if you didn't have a problem with withdrawal liability. I hope to provide, if not a solution, at least a workable framework here within which you can address this problem. So just brief background. 1980, Congress created the Multiemployer Pension Plan Amendments Act. Through the rest of these slides and this conversation, it'll be listed as MPPAA, or I'll just call it the statute. This statute, the main thing from our perspective that it did was create withdrawal liability. Most people call this an exit fee to get out of a fund. That's essentially what it is. It's usually a pretty substantial amount of money that's hanging over an employer's head, but it's not triggered until they have a cessation of the obligation to contribute, and we're going to get into exactly what that means in later slides. A few basic points about withdrawal liability and things to remember about your participation in a fund. Your obligation to the fund extends beyond your collective bargaining agreement. You need to check trust documents, maybe the rehabilitation plans, participation agreements, things like that. A lot of employers make the mistake of thinking that their obligation is solely embodied in the CBA. And while that's largely true, it's not entirely true. There are many different ways that withdrawal liability can be triggered. We'll discuss some of those more specifically as we go, but know that a failure to make the contributions, which are called for under the CBA, is not a withdrawal. Withdrawal liability turns on the legal obligation to contribute, not the mere fact of contributions. And down there at the bottom of that slide, plans monitor contributions through these audits. Many of you have probably been through audits and you know how onerous those can be. Those also can have a impact on your knowledge of withdrawal liability, and there's something to pay attention to. So let's see, the MPPAA sets up withdrawal liability here on this third slide, and it does so through either a complete or a partial withdrawal. We'll discuss each of those in turn on the next slides, but in a withdrawal liability, the plan determines, notifies, and collects the withdrawal liability. And I would add, it's like the old monopoly rule. You do not pass go, do not collect $200. It's pretty much slanted the fund's way in each of these instances. Let's talk about what those mean. And if anyone has any questions about any of this, please feel free to submit them, and I'll try to address them at a decent point or at the end. If we have some time left, we'll take some questions then too. So a complete withdrawal. What's a complete withdrawal? Again, it turns on the legal obligation, as I just mentioned on the prior slide, and it occurs when an employer permanently ceases to have an obligation to contribute, or they cease all covered operations under the plan. It's basically when you shut down, sell, you might bargain out, the union might decertify. Those would all trigger a complete withdrawal. Down there at the bottom, I mentioned this expulsion. This is increasingly coming up with different funds. that use some of their own fund rules, typically for what they call adverse selection, to kick an employer out of a fund. And once you're expelled, that could trigger a withdrawal liability as well. Adverse selection generally means there's differences in the rates at which you're contributing for different employees. Sometimes they'll have a rule that says you can't cover an individual rather than a classification, a full bargaining unit, or companies might have a non-covered unit that a fund will argue is an adverse selection on the fund. Talk about a partial withdrawal. 3 different ways to trigger a partial withdrawal. One's a 70% decline. I say they're on the slide over a 3-year period. It's generally, there's a testing period, and most of you are probably familiar with that. If you're not, it works like you look back over the 5 years previously and look at the 3 highest consecutive years, and that's what you have to judge your 70% contribution decline. So you have a 3-year testing period that looks back. The 5 years before that is the average for your contribution base units. We'll talk about what that means here in a minute too. And if you fall 3 consecutive years, 70% from that high average, then you'll trigger a partial withdrawal. It's basically, shorthand is it's a 70% decline for 3 straight years. You can also have what's known as a bargaining unit takeout. That's the second example there. There's also a facility takeout that's spelled out there, and this is where you would cease to have a obligation to contribute under 1 CBA, but the company would have more than 1 CBA, or a cessation of the obligation at a single facility and to continue performing work at that facility. This next slide talks about a mass withdrawal, which is not a typical situation, so I don't want to dwell on it too long, but know this, there's a few interesting consequences for employers who could find themselves in a mass withdrawal. Your unfunded vested benefits would be allocated proportionally, and that's all of them, including this reallocation of unfunded vested benefits. The reallocation are amounts that the fund deems are not collectible or have otherwise not been collected. It happens quite a bit that employers go out of business, they go bankrupt, they don't pay their withdrawal liability. Those amounts are not collected by the fund, and in a mass withdrawal situation, the fund turns around and reassesses those to all the employers that are part of the mass withdrawal. It's not a good spot to be in because it's a lot more money involved. You also see there the 20-year cap, which we'll talk about later on as well. The 20-year cap no longer applies, and that can be a very big deal, as we'll see later on, because withdrawal liability is payable over 20 years and no more than 20 years. That's the general rule. If you end up in a situation where the plan terminates because of a mass withdrawal, that rule will no longer apply, and you'll be liable for much more money. There's a few special rules that are applicable in various industries. The most commonly discussed one is the construction industry rule. That's spelled out there on the slide. Basically, if a employer in the construction industry and the plan has most of its participants in the construction industry, then a complete withdrawal would occur only if the construction employer no longer had an obligation to contribute but continued to perform the same work. So if a construction employer just shuts down and doesn't continue working and doesn't resume working within 5 years, there's no withdrawal liability for that construction employer. Let's talk briefly about how you calculate withdrawal liability. As I mentioned before, the fund would allocate a certain portion of the unfunded vested benefits. The unfunded vested benefits is exactly what it sounds like. A participant in a ERISA-regulated fund, is entitled to their vested benefits, benefits that have vested. The fund will calculate what those vested benefits are, and then they'll look at the money that is available that its participating employers are contributing, and the difference between those two is the unfunded vested benefits. It's benefits that the fund is going to have to pay at some point, or assumes it will have to pay at some point, that are not funded by the participating employers. A portion of that is assessable to begin the calculation for withdrawal liability. Note that I say begin because we'll touch on this as well later when we discuss the annual payment. But many funds want you to believe that your unfunded vested benefits are your withdrawal liability, and due to the application of the annual payment and the 20-year cap that I mentioned, that's generally not the case these days because the funds are so underfunded currently that the amount of the unfunded vested benefits that would be allocated to an employer are usually much more than the amount that that employer would end up paying if that employer were to actually trigger a withdrawal. And we'll talk about that some more as well. These payments are generally payable with interest in annual installments. I mentioned already the 20-year cap. You see that spelled out there, and at the bottom I put that the fund is supposed to give you, with their demand for payment, typically called an assessment, a schedule of your payments, and that's how many of those level annual installments you would have to make and for how long. That should come with the assessment. Now, if you were to get an assessment, there's a few brief points that I want to make about that. Basically know that arbitration reigns supreme. An assessment, you get a piece of paper in the mail from the fund. It's a letter that says, oh, by the way, the fund has determined that you have withdrawn from the fund and triggered a withdrawal, and you owe us $5 million. Here's your schedule of payments. You can start paying within 60 days, and here are your rights to request review. And you get that piece of paper, and most often, especially in the legal world, we think, oh, it's just a piece of paper. We'll run out and get an attorney and we'll fight this, and we're not paying anything until this goes all the way to the Supreme Court. That's not how it works in withdrawal liability. We'll discuss here in a minute how you have to make these payments even while you're challenging it, and we'll talk about what that means. But you get this letter, and you might think, that's just a letter, it doesn't mean anything. That's not true. It's a notice of withdrawal liability, and you have to arbitrate all disputes about that. If you miss any of these deadlines, you will not be able to dispute it, and you'll be stuck with the full amount. This is a brief timeline that lays out some of the deadlines that you would have if you received a notice of withdrawal liability. You get the assessment. As I note there, you have to begin making the interim payments. Generally, there's a few very, very limited exceptions that you never see apply, but I suppose they could. But you have to begin making interim payments, and your payments begin no later than 60 days from when you receive the assessment. Many funds put in the schedule that you'll start paying before that 60 days runs. So you might get a withdrawal assessment that says your first payment is due next week, or your first payments are due immediately. We'll talk about that too when the funds try to default you. You have 90 days to request a review about that assessment, and it's just another letter that you send back to the fund and tell them, here's what I think is wrong with your assessment, and we're requesting that you review it. That's a precursor to, you see the third block over there, the notice of initiation of arbitration. If you don't request a review, you can't initiate arbitration, and so don't miss that 90-day deadline. After you have requested review, the fund is supposed to respond. Oftentimes they do not because they hope that you're not very familiar with the rules and that you'll be just sitting there waiting for their response. If they do respond, that starts a 60-day window within which the employer can initiate arbitration. If they don't respond, don't just sit back and think, oh, well, I'm just going to wait until they respond and then we'll go from there. After 120 days from your request for review, that 60-day window opens on its own. And if you miss that opening and then miss the 60-day period, even if you have requested review, you would have missed your window to initiate arbitration. Now, I mentioned this idea that you have to pay now, dispute later. Some say pay now, fight later. In any event, even while you're disputing the withdrawal liability, you have to make the payments consistent with the schedule that the fund has provided with its assessment. These begin within 60 days. As I mentioned before, often it's sooner than that. And it's certainly, you notice the 60 days is much less than the 90 days that you have to request review. So generally, by the time you request review, you're already supposed to be making payments. We'll talk here in a minute about this default, and you see I mentioned that at the bottom of this slide. If you don't make these payments, you can be held in default by the fund. And we'll talk about a missed payment default versus an insecurity default. I don't want to get too deep in the woods on this. There's another slide behind this about it, and I'll cover some of the basics. But if you want a little more information, I wrote an article called My Fault, Your Fault, Default that you can request from me. I'll be happy to send it out, and it spells out the differences there and why it matters. We'll touch on that briefly here on this slide. This slide, at least the top here, is failure to make payments as a missed payment default. That's when you get the schedule from the employer, you don't make a payment, and before they can hold you in default, they would have to send you a notice to cure. And if you get a notice to cure and don't make a payment within 60 days, then the fund can accelerate the entire amount. However, in the initial stages of a withdrawal liability assessment, that is after you've just gotten the assessment and you're still within the period to request review, or if you have requested review and you're still in the period to initiate arbitration, there's a regulation from the PBGC that says that the fund cannot accelerate the entire amount. They can only accelerate the missed interim payments. So most funds right now, and this happens quite a bit, but most funds don't attempt to accelerate the entire amount until the employer fails to initiate arbitration because of that regulation from the Pension Benefit Guarantee Corporation that sort of stays the full impact. But they can accelerate at least as to the missed payments, and once you've missed your date to either request review or to initiate arbitration, then the full amount is able to be accelerated, and that's what funds will do. And you won't be able to do much about it once you've slipped into default. Down here at the bottom, there's a brief mention, this other event defined in plan rules. This can be this insecurity default, so-called insecurity default. This is not due to any missed payment. It's usually due to the application of a fund rule, and the fund will make its own rules as to what event might trigger a quote insecurity default. It's usually due to bankruptcy of the employer or an assignment made to creditors. They're liquidating assets, things like that. But some of the fund's rules are rather broad and give them pretty broad powers to accelerate, and they accelerate the entire amount. There's been a few court cases on this, and it's kind of a big deal. Some funds are even accelerating the entire amount due on a withdrawal liability right up front from the day that you get the assessment. They say, here's your assessment, and oh, by the way, the entire amount is due because we're accelerating it under our fund rule because either the employer, declared bankruptcy or was going out of business or some other reason that the fund comes up with, and they say, yeah, you owe us the whole amount right now. And it could be millions and millions of dollars. another point there, and this is addressed in that article that I mentioned on the last slide, the funds will, some of them try to get cute with this, and they'll avoid providing a schedule of payments, just saying, well, you owe us the whole amount. And they won't do the underlying calculations that we're going to talk about as to the annual payment and the 20-year cap. So by accelerating right at the outset and calling it an insecurity default, they're trying to avoid application of the schedule of payments requirement, and that is calculating the annual payment and the 20-year cap. And so remember, I mentioned earlier that the 20-year cap can often limit your unfunded vested benefits quite significantly, and the amount that you would pay as withdrawal liability can be significantly less than the unfunded vested benefits. Well, the 20-year cap is why, and the annual payment is why. When the fund accelerates and puts you in default and avoids giving a schedule of payments, what they're often doing is avoiding the 20-year cap, and that can be worth a lot of money. So, and you'll see that'll become more clear as we discuss some of these other issues in calculating the annual payment and the 20-year cap. A few business planning issues. This is just things to know as you're running your business. Be aware of different relief provisions that exist, and there aren't many, and they're not great, but they're all we've got under the statute, and it's worth knowing about them. This de minimis reduction is not matter too much these days, because it's basically you reduce the withdrawal liability by $50,000 or 0.75% of the plan's unfunded vested benefits, whichever is less. These days, it's always $50,000 is less, but that only applies to a small withdrawal liability assessment in the first place. It's phased in dollar for dollar and phases out at $150,000. Now, $150,000 to me is a lot of money, but in the withdrawal liability world, it's peanuts. And so this de minimis reduction truly is de minimis, but it is worth knowing about if you have a situation where you have a small withdrawal liability. This 20-year payment cap we're going to get into, that matters quite a bit, and you need to be familiar with it and aware of it, because oftentimes business owners will think that they owe a lot more withdrawal liability than they may actually owe if they were to trigger a withdrawal. And we'll talk about that. I know I keep saying that we'll talk about it, but we will. We'll get to it. And we'll show you how to calculate your annual payment. I'll show you the 20-year cap, and you'll see what a big difference that can make, and often does for a lot of employers these days. The sale of assets exemption, you need to know this as a business owner when you're either buying or selling another business. This is under Section 4204 of ERISA, and we'll come back to that in another couple slides. We'll talk about what you need to look at if you're buying or selling and what the withdrawal liability impact is. And then the last one, the sale of assets limitation. This one's not widely known, not widely utilized, but it applies where you sell all or substantially all of a business's assets. There is a cap on what the fund can get, and we'll talk a little bit about that too. Another thing to know as a business owner is your control group liability, and there's a couple slides on this, and I'll try to get through them quickly. The main thing you need to know is the control group, any other businesses that you own that are under common control can be jointly liable for your withdrawal liability, and the fund can come after any member of the control group to get payment. And that's what they often do. You'll often have a business owner that owns a couple different businesses, and one of them has withdrawal liability, and that business owner may think, well, we'll just shut down this company, put it out of business, declare bankruptcy, whatever, and that's that. These other companies are separate. And they may be separate, but the fact that they're commonly controlled by the same owner can put them in the control group, and the fund can come after the other businesses to pay the withdrawal liability, even of a business that was not economically related. So let's talk about what is a controlled group. 2 or more organizations that are trades or organizations and under common control. There's parent subsidiaries and there's brother sisters. Those are defined in the tax code. You may have a tax attorney that can spell that out for you exactly. Generally, it's interlinking entities that have an 80% overlap of ownership. Now, I'm giving you the basics here, and if you own other businesses or are affiliated with other companies, then maybe it's not even a business. We'll talk about this here in a second too. Maybe it's just you're leasing equipment to your company, or you have personal land that you own and you're leasing that to the company, or a building or something like that. That can be a trade or business. Remember on the prior. I'm sorry, it's on the next slide. A trade or business, whoops, sorry, that can be a part of your controlled group and could make you even personally liable for the withdrawal liability. So, oh, sorry, I'm going the wrong direction. So the important thing to know about control group liability is that it can even if the one company is not responsible for it because there's no money left there, the other companies that are doing just fine can be held responsible. There's a few rules here that I've put on this slide. If one member is assessed as withdrawal liability, that counts as notice to all the groups. So that's another tricky issue that has tripped up many employers, where they think, well, the notice came to the shut down business. I didn't get any notice at my thriving businesses. That doesn't count and it doesn't matter, and they can't come after them anyway. That's not how it works. And notice to one has often been construed as notice to all. There's also another way that the funds can come after other businesses. They hold them to be an alter ego. And it's basically where you're running 2 or more companies just like a single entity. You're not following the corporate formalities, etc. Some of the factors are spelled out there on this slide. Here's the point about trade or business. It's an organization that is engaged in an activity for the primary purpose of income or profit, with continuity and regularity. And you say, well, what does all that mean? Just tell me what it means. Well, it can mean another business, but like I said, it doesn't have to be a business. It's not income as an employee, and it's not passive investments in stocks or bonds, but look at the point there towards the bottom of the slide. It extends to leasing activity or earnings as an independent contractor or a consultant. So the owner of a withdrawn trucking company, I use this example, could expose his personal assets if he's leasing other property to third parties, even if it's not related to his trucking company. If he's runs his own, he owns an apartment building or something, and he's leasing that out to others. Or more often is where he runs the company and he leases the land or the building to the company, but he owns the land or the building personally. That could be viewed as a trade or a business, and because it's owned wholly by that owner who also owns the withdrawn entity, that could be 2 separate trades or businesses that are under common control. If the company went out of business and didn't have any money left to pay its withdrawal liability, the fund could very well say, that's okay, we're counting your lease of the building and or land to the withdrawn entity as a trade or business, and we'll take that, and we'll hold you personally liable for it. This happens in the 7th Circuit where I am. I'm in Chicago. This happens quite a bit. And a lot of the decisions, you see I cited one here from a couple of years ago, set forth this leasing property rule, they call it. And they say that if you're leasing property to a withdrawn employer, that makes you a trade or business. This case that I cited here at the bottom, this Hanna Brothers case, the related entity leased tugboats to the withdrawn employer, and because it leased those tugboats, the case held that that was under the leasing property rule. It was under common control and was also responsible for the withdrawal liability of the withdrawn employer. This is a quote from another case from a couple years ago, and just think about how broad this rule is. This is a quote directly from the case. In sum, if an individual engages in a trade or business under common control with the withdrawing employer by leasing his property to the withdrawing employer, he is personally liable for payment of withdrawal liability. So if you've got personal property that you're leasing to an entity, whether it's incorporated or not, whether you've set it up as a separate business or not, that's something to look at under these control group issues, and it's a significant business issue that I see come up quite a bit. And it's something that you want to be aware of as a business owner to make sure that you don't end up in a spot where you're paying withdrawal liability with funds that you didn't think you would have to. It sets forth the rule and basically how it applies there at the bottom of the slide, where the individual owns the property on which a withdrawing employer conducts its operations, leases the property to the withdrawn employer, and owns the withdrawing employer, then that individual is personally liable for the payment of withdrawal liability incurred by the withdrawing employer. That's pretty scary for some business owners that may be doing that. So pay attention to that and be aware of that. There's another provision that funds are increasingly using. I won't say much about this evade or avoid provision in the code there under the MPPAA. This 29 U.S.C. 1392. Just know that the funds are increasingly using this provision to try to set aside transactions that they don't like. And they're using it very broadly. And that seems to be the scope of a lot of things under the withdrawal liability statutes. They're bad enough in that the statute is slanted very much against employers, but a lot of these issues are decided against employers, and it's happening that way in this evade or avoid statute as well, where they're saying that transactions that were entered into with a principal purpose to evade or avoid withdrawal liability, the fund can just disregard those and pretend that they didn't happen. And there's, use your imagination. You can come up with all different kinds of transactions that funds would try to set aside to get after the money that they're so desperately trying to get. And that's exactly what's going on. Another issue that comes up, and this has really been a big issue in the last couple of years, is the successor liability. This is something you need to know if you're buying or particularly buying, but also selling your business. The general common law rule has always been that a sale of assets, the liabilities do not transfer, and a lot of people still rely on that, but that's been less and less true in the withdrawal liability universe. I cite a couple cases down there from a few years back from the Ninth Circuit and from the Seventh Circuit. There's more since then, and those cases, it shows that it's increasingly likely that the buyer of an entity that has an obligation to contribute to a pension fund can be liable for the withdrawal liability of that entity if it had notice of the liability and sufficient evidence of continuity of operations after the sale. And I cite some of the factors there for you to look at. This resilient floor covering case basically said if you took over all the customers from the withdrawn entity, then that was the most significant factor to look at in imposing withdrawal liability. And it can be pretty scary and can come with a high price tag too. So make sure you pay attention to that. It's actually been a big deal for a lot of business owners on both sides of transactions, because it's made it harder to sell a unionized company. So many people don't want to risk it and don't want to buy a unionized company with any sort of obligation like that. So it's made things tricky there. Mergers, stock sales, there's generally no withdrawal liability there because as long as the obligation continues, a change in the organization is not going to trigger a withdrawal. But this sale of assets, here's where I want to touch on this section 4204 that I mentioned. If you're selling your business and you're looking for somebody to take it and not trigger a withdrawal, because remember back at the beginning I said one of the ways you can trigger a complete withdrawal is to sell the business that contributes. Well, under this section 4204, and that's section 4204 of ERISA, there's a process through which you can go if you're selling the business to make sure that the withdrawal liability is not triggered. That's spelled out here on this slide, this slide that has at its top section 4204. There's these requirements here that if you comply with these, withdrawal liability will not be triggered. It needs to be a bona fide arm's length transaction to an unrelated party. You can't sell it to your wife or something like that. The purchaser has to take the obligation to contribute. That generally means that they take the collective bargaining agreement, but it doesn't have to mean that. They could just take the obligation to contribute and still negotiate their own collective bargaining agreement that maintains that obligation to contribute to the fund. They have to have that obligation for substantially the same number of contribution base units, and we'll talk about the contribution base units. That's just what, like if you contribute so much per hour or per week, per month, per day, whatever the period is, that's your contribution base unit. And the purchaser has to take that obligation for substantially the same number for 5 years and post a bond. That obligation is generally determined at the time of sale. So if it turns out in fact that the obligation dropped over those 5 years, that's okay as long as they took substantially the same obligation at the time of the sale. If it turns out that the business didn't turn out as good and so they dropped and it wasn't exactly the same, it may not have to be. The third requirement to avoid triggering withdrawal liability there is the seller has to agree as part of the sale contract, and this usually is stuck right in the purchase sale agreement, the seller has to agree to secondary liability within the first 5 years after the sale. So if the purchaser gets the business and triggers a withdrawal and then doesn't pay its withdrawal liability, the seller is still on the hook for 5 years, and that's put in the contract. If you comply with those requirements, there is no withdrawal liability, and you could successfully sell your business. A few other considerations here under Section 4204. The buyer just assumes 5 years of contributions history. Now, we'll see here in a minute that when funds are determining withdrawal liability, they can go back 10 years to look and see what the contribution base unit history was and what the high contribution rates were. So this could be something to pay attention to, because if you buy a business here, you're only assuming 5 years of contribution history. For that employer, it could be that their contribution history was much higher 10 years back than it was 5 years back, and that's something to pay attention to, because that entity may have a higher withdrawal liability, higher amount that they would pay in withdrawal liability for themselves than the buyer would if they only look back 5 years, because the entity itself the fund against the entity itself, the fund would look back 10 years. So that's something to pay attention to. If you're purchasing it without explicit assumption under 4204, the buyer should still analyze the successorship issues that I talked about a few slides back. A lot of buyers go through the transaction. They think, I haven't taken anything on here. The sales agreement doesn't say that I'm taking withdrawal liability, or even it might say that you're not taking the withdrawal liability. And the fund could still argue, if that withdrawn entity doesn't pay, that because you took on their name, their customers, et cetera, that you're basically continuing the business, and so you're their successor, and now you're responsible for it. Funds are getting increasingly creative in this area, and it's something to really pay attention to. And that's as I mentioned before, that's why a lot of people want to stay away from purchasing a unionized business unless the opportunity is just right, because this is a pretty significant consideration. I mentioned previously the Section 4205. This is the sale of assets limitation. If you have a bona fide sale of all or substantially all of the employer's assets in an arm's length transaction to an unrelated party, then this section of ERISA, again this is Section 4205 of ERISA, limits the unfunded vested benefits that can be portioned out to the employer. And they have an actual chart in the statute that sets forth what the maximum amount of unfunded vested benefits would be. Now, I said that this one is little known or utilized, but it turns out that when the statute was written, Congress did put in there that, at the end of the day, if you sell everything off and you're paying everything off and that's all that there's left, there is a limit to what the fund can get, and it's spelled out there in the chart in the statute. And I didn't include it in here, but I think the first step on that chart is like up to $5 million. It's 30%. So it's a pretty significant reduction, and it goes up from there. I think the chart goes like 5 million, maybe 10 million, then on up from there, and it goes 30, 35%. But it can be a pretty significant reduction, especially given these days where we're most often talking about millions and millions of dollars of liability. That could be a significant limitation on that if you're honestly just selling your assets and shutting down and paying everything off and going away. Final thing here on the business planning issues to pay attention to is the timing. The timing of a sale, the timing of a withdrawal. If you're shutting down and your business is faltering and you're ready to close it up, the timing of it can make a big difference. And the reason is that withdrawal liability is determined by plan years, and it's determined year over year, calendar year, and it doesn't matter when you withdraw in that year. And it could be plans often have a calendar year, plan year from January 1 to December 31, but sometimes it's April 1 to May 31 or October 1 to September 30th. Whatever. The plan can pick whatever its year is. But the withdrawal liability calculations change quite a bit year over year, and that's due to the assumptions that are used, the rates of return, how the stock market performed. That can make a big difference. And so if you're shutting down, pay attention to the timing on it and know if you're close to a plan year rollover, because it may be that you want to hurry up and do whatever you're doing before the next year, or it may be that you want to wait until the next year. It all depends. But that's something that can make a big, huge difference. All right, quick legislative update here. This MPPAA that's referenced here, the Multiemployer Pension Reform Act, was passed in 2014. It was supposed to help save pension plans. It really hasn't, and it's sort of a long line. You can go back to 2006. They passed the Pension Protection Act, and they amended that in 2008. They had a few other things in 2010. Then 2014, the Pension Reform Act, and now, as you'll see on the next slide, Congress is meeting. Even today, they've got this new way to rescue, or new chance to rescue pension funds. But this Multi-Employer Pension Reform Act did have a silver lining for employers. It hasn't really saved the pension plans. That didn't work out like everybody hoped. But there is a silver lining for employers. And you note there I put at the top, important. These increases in your contribution rates, the contribution rate that you pay to the fund, if they were required or made in order to enable the plan to meet the requirements of a rehabilitation plan. These definitions are funding improvement plan or rehabilitation plan. Most often it's a rehabilitation plan. They're both basically the same thing, but they're determined as to whether you're endangered state, the fund is in endangered status or critical status. They're both, the law says that the fund has to come up with a plan to try to turn that around, whether they're endangered or critical. And in one instance, they call it funding improvement plan, and the other they call it rehabilitation plan, but they're basically the same thing. But the contribution rate increases are are disregarded under the Multiemployer Pension Reform Act. Any increases after December 31st of 2014. Now I guarantee you, all of you on this call, your contribution rate has gone up every year since December 31st of 2014. And that increase will not count against you when you're determining the annual payment. And we'll see how that matters here in just a few slides. But note that the fact that you can use your contribution rate from before December 31st of 2014 can be a significant savings if you were to trigger withdrawal liability. Now I mentioned this new Joint Select Committee. This arose out of the Bipartisan Budget Act of 2018, which just passed, I think in late January or early February. Anyway, they set up this new Joint Select Committee on the solvency of multi-employer pension plans. 16 different lawmakers, 8 from the House, 8 from the Senate, 8 Republicans, 8 Democrats. They had their first meeting last month. They're meeting again today. I think it's at 2 o'clock this afternoon Eastern time. So basically around when we're done with this call, they're meeting again, and that's probably broadcast. I didn't check this for sure, but the last one was broadcast on their Joint Select Committee website. Basically, they got this group together that's supposed to come up with legislative language to significantly improve the solvency of these multi-employer funds. This is the first time where I felt like, who knows? I'm not optimistic on this, but who knows if they got together and came up with something. Now this basically means bailouts, but a lot of the plans that they're talking about are federally backed loans, low interest loans, things like that. But whatever they come up with, if they get a majority approval from both sides of it, that is 5 Republicans, 5 Democrats, then the legislation that they've come up with will get an expedited vote in the Senate with no amendments. So they have at least crafted something that if they come up with something, they should get a vote on it. And who knows, it could pass. But for my money, Congress starts tinkering with stuff, you're just as likely, in fact, you're more likely to get shafted than you are to get saved, and especially the employers. You guys wouldn't be in this boat, you wouldn't be in this call if Congress hadn't acted the first time. And what did they do? They stuck you with this thing called withdrawal liability. Never made any sense to me because the employers are the only ones that have done everything that they said they would do. You guys have made your contributions. You paid everything that you agreed to pay, and yet you're the ones who have to worry about this big mess. Well, anyway, I'm going to tell you a little bit here that we're moving into the wrap-up session here. So this is things you need to know. Know these rules. I'll lay out a few of these things, and then we'll talk about how you can calculate what your payment would be. And this may give some of you at least a little bit of silver lining on your withdrawal liability. That if you look at how you calculate this, things might not be as bad as you think. It's like I tell a lot of my clients. I say, yeah, this withdrawal liability, you're screwed, but you might not be as screwed as you think. And because of the amounts of money that we're talking about are massive, you save a little, you can save a lot. So here are the takeaways here and what you need to know. Know your obligation. Know the collective bargaining agreement. Know what you're supposed to contribute, the rate, the hours, whether or not you're supposed to contribute for overtime, vacation, if there's any caps in there. Oftentimes when I deal with employers that have had withdrawal liability, you go back and start looking at what they've been contributing, and it's often there were mistakes made, and maybe they've been paying more than they should have. Maybe there's a provision in the CBA that says you're not going to contribute for more than 40 hours a week or something, but nobody caught it, and you've been sending contributions. Take a look at all that and just make sure that you're familiar with what you have to contribute for under your collective bargaining agreement. It makes a difference for not just the ongoing obligation of what you're paying month to month usually, but it makes a difference, can make a difference in the calculation of the withdrawal liability. Because remember, I mentioned early on how withdrawal liability is determined based on your legal obligation to contribute, not the mere fact of contribution. So if you stopped contributing, that doesn't trigger a withdrawal because you still are legally obligated to contribute. Conversely, if you're over contributing, the fund may take that money and we could have a whole separate presentation about whether they get to keep it or how all that plays out. But they might look at it as, oh, well, you were legally obligated to contribute that, and so your contributions, your history is inflated. And if you have an argument under your CBA that you never should have been making those contributions, now's the time to find out, because it could increase your withdrawal liability payment as well. Know the pension documents, be familiar with those. Know your control group. Pay attention to that leased property rule, like I said. Know what entities might be in your control group and who might ultimately have to pay any withdrawal liability that comes about based on any business decisions that you make. How do you know this? Well, you can ask for an estimate, these information requests. Annual estimates are a good thing. They can be your friend, even though they might be very, and some of you are probably familiar with these where you request information from the fund and you get it. But I recommend that you do it every year, and you're entitled to do it every year. It lays out how the fund, it lays out what your withdrawal liability estimate would be, and on the next slide I'll show you something you can do to request it. Also know your fund condition. You probably get funding notices, know what the fund is using for its assumptions and returns, maybe even pay attention to their arbitration decisions. You're entitled to get all of this information. And here on this slide is how you can get what's the key point here is the estimate of withdrawal liability. You're entitled to this every year. You can send them a little note if any of you want it. If you want that article that I mentioned, just let me know. Or if you want this for this slide, I've got this sort of a form that I've created that you can put on your own letterhead and request the information from the fund. The key part of it that I bolded there, they'll tell you that you ask for the amount of withdrawal liability, and that's what they're supposed to give you, but often under the statute, they're not giving you your, quote, withdrawal liability. What they're actually giving you, and a lot of funds do this, I've seen a ton of it, they'll send you back a note that says, oh yeah, here's your withdrawal liability. It's $15 million or whatever the number is. That number is often the unfunded vested benefits. That's the starting point for withdrawal liability. That's not the end. And there's total difference under the statute between withdrawal liability and unfunded vested benefits. And we're going to talk about that and why that matters. Because here's how you calculate your payment. Again, the fund starts with unfunded vested benefits. We'll show you how it might end for you. And it looks this way for a lot of employers. A lot of the clients that I deal with come to find out that, yeah, their withdrawal liability is high and ridiculous, but it's not nearly as high as the unfunded vested benefits. And that results because of the annual payment and the 20-year cap. So let's talk about that. And this is key information for you. Two factors that you need to know to calculate your payment. One, contribution base units. I talked about this before and said that's whatever unit you contribute for under the collective bargaining agreement. So you have to pay $8 an hour to the pension fund. Well, your contribution base unit is hours. Or if you have to contribute so much per week, your contribution base unit is weeks. I hope you're following where I'm going. If you contribute monthly, daily, whatever it is, your contribution base unit is hour, day, week, month, whatever. Look back 10 years on that. Don't include the current year. So right now in 2018, you would look at your history from 2017 back through 2008. Look at those 10 years. Out of those 10 years, if you skip down just a bit on that slide, you see this annual payment. I say highest CBUs for 3 consecutive years. Your highest contribution base units for 3 consecutive years, not the 3 highest years out of those 10, the 3 highest consecutive years. You average those. That's factor number 1. So look back 10 years, find the 3 highest consecutive years of CBUs, average those 3 years. That's the first factor. Multiply that by your contribution rate. This one's much easier. It's the highest rate. And you look back 10 years, but this includes the current year, of course, because that's generally you're paying the highest rate. In fact, not generally, always. Your rate right now is the highest rate of the last 10 years. I've never seen it otherwise. I suppose I could dream up that it might be otherwise, so I guess that's why I say that. But your contribution rate, your highest contribution rate in your last 10 years is the rate that you're paying now. Now note that I put in the parentheses, also consider MPRA. Remember I mentioned before when we talked about the Multiemployer Pension Reform Act that your contribution rate after December 31st, 2014, any increases don't count against you for purposes of withdrawal liability if they were entered into to meet the requirements of a rehabilitation plan. Well, that's true for a whole lot of employers out there. Their funds are in critical status. The funds had to come up with a rehabilitation plan, and so they came up with a schedule that you probably had to comply with, where when you show up at collective bargaining, they say, here's your schedule that you need to do to comply with the rehabilitation fund, and here's the increases, 4%, 6%, whatever the increases are that they mandated, and that's sort of what you've agreed to. Even if you've just entered into them in order to comply with that rehabilitation plan, then those rates, those increases don't count against you after December 31st, 2014. So this is why I'm saying you may be able to use the MPRA to reduce your annual payment. Your highest rate has gone up since 2014, but you might be able to use the lower rate from 2014 when calculating your annual payment if you were to actually withdraw. So you take those two factors and multiply them together. The average of your highest 3 consecutive years of CBUs times your highest rate equals your annual payment. That's what they can make you pay each year. Now oftentimes with a lot of funds these days, they're so far over the cliff that they'll send you owe us $15 million in withdrawal liability. Turns out that that's unfunded vested benefits. When you take the annual payment, and they're supposed to provide you with a schedule of payments, this is the same formula that they've got to use when they're applying or when they're calculating the schedule of payments. They've got to figure out your highest CBUs times your highest rate. They can make you pay that annually, and with the 20-year cap, they can only make you pay that for no more than 20 years. Oftentimes, employers that I deal with, their funds are so underfunded that it turns out that that's a big, big savings. And in my example, let's say there's $15 million of unfunded vested benefits. For a lot of employers, their high years, their high CBUs were 8, 9, 10 years ago. So depending on the timing of the year of withdrawal, and you can look back and you can look forward and see what CBUs are going to drop off versus what you anticipate coming on, and you can determine the timing of a withdrawal or what difference it would make if you withdrew in one year versus another. And it matters a lot depending on your history, but you only look back 10 years. So some of those high year CBUs, if those were in 2000, say 8, 9, and 10, they may be dropping off for you in coming years, and the highest rate doesn't count against you even when it goes up because of the Multiemployer Pension Reform Act. So your annual payment may remain steady or drop even, and while your unfunded vested benefits are going up, the amount that you would actually pay is remaining steady or declining because of the annual payment and the 20-year cap. So that's something that's really worth emphasizing here. So I'll end with this. Timing is everything here. I mentioned this 10-year drop-off. Pay attention to that. When you know your history and know what how to calculate the annual payment, you can figure out sort of what you would actually pay. Pay attention to that 20-year cap. Pay attention to present value. You actually have the right under the statute to prepay your withdrawal liability. They give you the schedule for 20 years, but you can pay it in a lump sum. You have that right under the statute. So the effect of the Multiemployer Pension Reform Act can provide you with an opportunity maybe even to limit your withdrawal liability somehow. And a lot of, as pension funds have hit the skids these last couple of years, a lot of employees have realized that the pension fund is maybe not in their best interest either. And there's opportunities for negotiating out of pension funds now that did not come up just even several years ago. The pushback from the unit may be much less now that employees know that their benefits are potentially getting cut. That was another effect of the Multiemployer Pension Reform Act. And they've soured on pension funds generally. So you might not get the pushback that you thought. And depending on the timing, it could be worthwhile because it may be something that you can pull off. That is, your withdrawal liability might be a lot less than what you thought it was because you're looking at the unfunded vested benefits. And when the fund gives you the estimate, that's usually what they're giving you is the unfunded vested benefits. And that's why I highlighted or bolded on that page the application of any limitation. They're supposed to give you the application of the limitation, i.e. the 20-year cap. They never do that because they want you to be scared to death about getting out of the fund. They don't want you to get out of the fund because they need you to stay in it. And who knows, maybe it's in your interest at least for now. But when you're armed with a little bit of knowledge here as to how the annual payment and the 20-year cap works, it may be that you can figure out that your withdrawal liability is something that you could manage. And in many instances, it turns out to be that the employer's withdrawal liability, if you factored it out over the 20 years, is less than they would pay if they stayed in the fund over the next 20 years with the increases that are coming. So oftentimes it comes down to paying a mortgage versus paying rent. That's all that I've got. I told you I would show you a good picture of me. There I am. Sorry we've got to end on a down note, but thank you for being here and thank you for paying attention to this. Thanks for being part of Conn Maciel. You can come back and revisit this. It is recorded. We expect to have it available with the slides in a few days, and please sign up for other presentations. Thank you very much. Goodbye.